The Sham Trial by Roger Hallam. From the very start, it was clear our trial was a farce. The judge's orders to arrest defendants and frequently send out the jury spoke volumes about the repression we face. This wasn't just an ordinary trial. It was a rigged spectacle aimed at undermining resistance to the carbon regime. We have faced a legal charade where the jury were denied crucial context. We gave 250 pages of scientific backing to our actions, but it was denied. 4 key facts about the climate crisis and our protest were eventually agreed to, but the judge dismissed their use in our defence. How can justice be served when the jury are kept in the dark about why we took action and the urgency behind it? It's a blatant disregard for fairness. The prosecution's claims of conspiracy against me were laughable. There were no documents, no records of meetings, and no proof linking me to any organised effort to disrupt the M25 gantries. The entire case rested on a 20-minute Zoom talk, a standard part of advocating for general civil disobedience, not evidence of a particular conspiracy. The lack of substantial evidence is a clear indicator of the trial's true nature, a sham designed to silence and make examples of us, not to pursue justice. We were charged with causing a public nuisance without reasonable excuse. But let's be real. Our resistance was aimed at addressing the incoming catastrophe of greenhouse gas emissions, a crisis acknowledged by 99% of scientists, the UK Parliament and the UN. The law allows for reasonable excuses when it comes to public nuisance, especially in the face of such an urgent and existential threat. Ignoring this context twists the law into something unrecognisable and unjust. Our trial wasn't just about whether we broke the law. It was about whether the law serves justice. With the planet on the brink of catastrophe, causing a public nuisance was a necessary measure to demand urgent action. Our actions were not only justified, they were essential. We acted out of desperation to push for the change that's needed to save lives and protect our future. This case is a glaring example of how the justice system can be manipulated to crush legitimate dissent. When a trial is based on flimsy evidence and ignores the broader context of our actions, it's a mockery of justice. This sham trial sets a dangerous precedent of criminalising dissent without fair consideration. The integrity of our legal system and our commitment to real justice hangs in the balance.